Welcome to Ideas of India, where we examine the academic ideas that can propel India forward. My name is Shruti Rajagopalan, and I'm a senior research fellow at the Mercatus Center at George Mason University. Today, my guest is Justice Jasti Chelameswar, who is a former Justice of the Supreme Court of India. Prior to his elevation, he served as Chief Justice in High Courts in Guwahati and Kerala, and as a Justice in the Andhra Pradesh High Court. We spoke about his judgments on electoral qualifications, judicial conduct, transparency in judicial appointments, the constitutional right to privacy, separation of powers, and how dissent shapes constitutional interpretation, and much more. For a full transcript of this conversation, including helpful links of all the references mentioned, click the link in the show notes or visit mercatus.org/podcast. Jasti Chelameswar, welcome to the show. It is such a pleasure to have you here.
Thank you.
So when I was preparing for this conversation, I realized that you've written a lot of opinions on election matters, and they have a similar connective tissue. One is the need for greater transparency in processes relating to elections and more generally democratic processes. But in addition, I've noted that your view of separation of powers is much stricter compared to many of your colleagues, especially when I read their opinions alongside yours. For instance, the P.A. Sangma case, where you, along with Justice Gogoi, took a very strict view of the disqualification for office under Article 58(2). In Rajbala versus State of Haryana, you again take a pretty strict view of the statutory requirements that the legislature has actually imposed on the question of what are the qualifications required for, anyone to stand for election. But when I look at Lok Prahari, it seems like you have a much more expansive view of, what is the role of the judiciary? Because here you almost reinterpreted, to my mind, what was the existing election law to classify non-disclosure of assets as a form of a corrupt practice. So when I read all these cases together, I feel like you have a very strong preference for strict adherence to separation of powers, and you're only willing to trade that off to increase accountability and transparency in the overall democratic process. Does that sound about right? Or how do you view these cases when you look at them together now in hindsight?
Yeah, if that's how you or anybody else understands my judgment, I'll be more than happy. See, ultimately, when we're talking about a democratic governance, talking about constitutional governance in a democratic republic, the most fundamental requirement is that there should be a elected government, elected in accordance with certain basic norms. So therefore, transparency and clarity in these matters, in my view, is very essential. That's been my belief from the beginning. You said you started the conversation saying that you have written a lot of opinions on election matters. Well, I didn't have a choice. It's the master of the roster who decides what cases should go before which. It just so happened a lot of election matters were heard by me over a period of almost 7 years. On a personal note, as a lawyer, I handled a lot of election disputes. Therefore, my acquaintance with that part of branch of law is, with pardonable pride, I can say, fairly good. Fairly good. For example, if you remember, repeatedly the Supreme Court held from 1950 onwards, from Pondaswamy versus Namakkal onwards, that all rights pertaining to election or statutory rights, there's nothing constitutional about that. Unfortunately, it has become a more of a rhetorical statement repeated by the Supreme Court without meaning any personal disrespect to any one of the judges. In fact, some of them are outstanding judges. It so happened it was not properly debated perhaps before that, and there was no occasion for them to do it. Now, if all rights are only statutory, there's nothing in the Constitution which forms the basis of the electoral process in the country. The whole democracy itself is very fragile. And in fact, I said it in the open court on one of those occasions when I was hearing these election matters.
Yeah.
If this is the real legal position, Mrs. Gandhi, former Prime Minister of India, and her legal advisors, I mean, once again, I would on the light tribune state, are not very wise people. In amending the constitution of Mrs. Gandhi's debacle in Allahabad High Court, in my view, you may agree, may not agree, it's up to you. In my view, if that's the real legal position, nothing prevented the parliament from simply repealing the RP Act retrospectively.
Yeah.
That whole disqualification of Mrs. Gandhi sprang up from an election petition based on a provision of the RP Act. Simply withdraw the act retrospectively, end of the story. There's no need to amend the constitution. Can be so fragile, I think. Now, point is, that I'm not on the merits of Mrs. Gandhi's case and what have.
Sure.
I'm giving an extreme example.
Yeah.
Now, it was in the POCL case for the first time, Justice Venkatram Reddy, one of my peers in the Supreme Court, incidentally hailed from the same parent court.
Yeah.
He didn't elaborate on it. He made a passing observation that the right to contest and right to vote, there is the constitutional rights. Though nobody ever asserted, nor did I even assert that these rights are fundamental rights.
Yeah.
But we believe that these are the rights springing up from constitution. Otherwise, the Article 326, which says, talks about the right to vote at the age of 18, subject to XYZ restrictions and so on, it would carry no meaning. Every legal document, be it the constitution or a statute or even a contract, every legal document creates rights and obligations. And to read and the second thing is, such elaborate arrangement in the constitution regarding the composition of the parliament, composition of the state legislative assemblies, the structure of the democracy, the president, vice president, so on and so forth, speaker, chairman, all these things. If all these things are simply dependent, all these things remain on the statute book, in the constitutional document, but then the rest of the rights to vote and contest have no basis in constitution, would lead to absurd concrete results.
Yeah.
This is what I believe that day, today, and that's what is reflected in the judgments. And this understanding of mine, apart from my own humble study of the constitutional law, I told you I handled a number of election cases as a lawyer.
Yeah.
While dealing with those matters, these questions invariably was thing in my mind. So when I had an opportunity to express my views, the alternate at the bar, whatever the lawyer says is only an argument. Eventually, it becomes a law and accepted by the court. Now, I had the first opportunity to go into this question by a sidewind in BMTK case, the symbols allotment matter. My opinion became a dissenting minority opinion. Majority did not agree with me. But I gave very elaborate reasons for this proposition, why these rights are constitutional rights and then more sacrosanct, it's not simple law. Then, of course, subsequently in Rajapala, though it is one of the highly criticized judgments of mine, I know that. And Rajapala, I had an opportunity because my colleague on the bench, the Sapre, agreed with me, with my logic. So what I wrote as a dissent in election symbols matter, that DMDK matter, it became a majority of the judgment of the court. Two judges agreed.
Yeah, two judges. You and Justice Sapre.
Sapre. And hopefully it is not a reverse. I am not checked up. Now, this is the background in which all these matters, when we were talking about either Rajbala, any one of these matters you mentioned. So similarly, in Pranab Mukherjee's matter. Pranab Mukherjee's matter, the court never went into the merits of the allegation.
Yeah.
It was dismissed at the preliminary stage. There are various questions, like whether Mr. Mukherjee was holding an office of profit.
Yeah.
It's a mixed question of fact and law.
Yeah.
Evidence had to be taken. On a simple affidavit evidence without any cross-examination, that question was said. If whether he was in fact holding the office on the date of the scrutiny of his nomination, because there is a relevant date on the election law. If he resigned, these are all questions of fact to be ascertained. You can't simply go by an affidavit without. Now, however, I guess the offices. In fact, I remember when the former President Giri's election was challenged, Mr. Giri did appear in person. I still remember I was a student of this.
Yeah.
Maybe out of respect for the office or out of respect for the age or whatever, the court offered a seat to him as a witness. Mr. Giri politely declined, saying that I'm a witness here. I would prefer to stand and answer. That's the true spirit of democracy. No, I'm not saying anything against Mr. Mukherjee, but the way it was dealt, I could not agree with it. I gave my reasons.
Yeah, your view was not that he actually held an office of profit. Your view simply was we must look into it because it is not a conditional disqualification the way we have in the case of members of parliament or members of legislative assembly. It is a very clean and simple, complete disqualification under Article 58(2), which again must be looked at on the question of law and fact, right? So it's a much more narrow opinion that you gave. It's more about the working of the court almost, more than the question of how you elect a president, right? You're smiling, but that's sort of how I view the way you wrote that opinion.
I'll tell you something. When you're talking about the working of the court, if you check up the dates, my dissenting opinion, the reasons were delivered much later than the main judgment.
Yeah.
Now, in other words, the other judges did not have the benefit of looking into my opinion. The Chief Justice thought it fit to pronounce even without looking into my dissenting opinion. The whole purpose of this constitutional benches are division benches. Number of the multi-numbered bench, I think, is defeated. Now, it's possible that all the four learned judges would have rejected my logic. But not four, only three. Another Ranjan Gogoi agreed with me.
Yeah.
Although he gave a separate. But his opinion was published along with the majority opinion. Fine. I mean, I was not ready. In fact, I requested the Chief Justice to hold on for a few days. I don't want to go into the further details, but these are facts on record. My opinion was delivered later. Obviously, the other judges did not have the benefit of my opinion. You want to talk about the working of it.
Yeah.
So, does not diminish the value of the majority judgment in the sense of its binding nature, but the working of the. Maybe somebody would have changed his mind after going through my dissenting opinion, if only they had the advantage.
Yeah.
And then second thing is coming once again to the DMDK matter, that election symbols matter. I gave an elaborate reason. Of course, I don't want to go into that. There was an earlier judgment of the Supreme Court dealing with the symbols allotment, that Haldar symbol of Janata Party. The Supreme Court observed earlier the judgment, Supreme Court had observed, when a party is not able to muster minimum number of votes, what kind of a political party it is, exact language I don't remember, or something like that. I said these majorities are very transient. The majorities only decide on every issue, the correctness and legality of every issue. In fact, I recalled in the judgment, Hitler was the greatest Democrat. The kind of majority with which he came to power. It's only majorities which decide the legality and constitutionality of the issues. They're all transient. Parties which secure tremendous majorities lost subsequent elections. Take the case of Churchill, the man who was so popular during the war, lost the next election. Anyway, that's the background in which all these judgments. Therefore, I always believe that these things require utmost caution before making any pronouncement on these matters.
Yeah.
This is the most fundamental aspect of a democratic republic. Now, when it came to Lokpratari matter, there are further questions. It's not only an election, periodic election mela, but we must also have quality of the representative class.
Yeah.
That was a requirement. Well, suppose nobody would quarrel with me on the proposition. Whether who is good, who is not good, who is the right kind of public, that is no thing.
Without going into the particulars, right? In the case of Rajbala, it's about educational qualifications and whether the legislature required that those who are standing for election have a toilet in their house. And there was some, list of qualifications. Now, that's a set of qualifications. Now, we can quibble. Any two people can.
One second. Remember, these are not qualifications for disqualifications for voting.
Not for voting, for contesting elections. Yes, absolutely.
So there is a distinction.
Absolutely.
See, so because that distinction, no, incidentally, whether you should have a toilet or not, I don't want to explain my judgment, it is there.
Sure.
But question is that distinction between the right to contest and right to vote are two different things.
Absolutely.
In fact, somebody attacked me personally in this, not physically, in a conference, that I drew an artificial distinction. I mean, I didn't understand. See, if the right to vote and right to contest is the same, anybody who is entitled to vote for an election at the parliament can become the president of India. There is an additional qualification of age there.
Yeah.
So therefore, there are distinct legal rights.
I think that part is very clear in your judgment. So the thing that I find quite interesting when I juxtapose Rajbala with Lok Prahari is now only talking very specifically about the right to contest, not the right to vote. So within right to contest, all the qualifications and disqualifications, what I've observed in your opinions across the election cases is you really care about what the legislature says, and as long as it's constitutional, those are the qualifications. In the case of Rajbala, the constitutionality you explained as these requirements of educational qualifications or having a toilet and so on and so forth, they are reasonable nexus within the classifications required by Article 14. What I find interesting is when we juxtapose it with Lok Prahari, you are not that strict in interpreting the statute. You give a slightly more expansive view of the statute where you equate non-disclosure to mean potentially a corrupt practice. So I think that's what's interesting to me about these two cases, where in one case it's quite strict and in the other it's quite open. And what might be the reason? So one potential reason could be you care a lot about the overall integrity of the transparency or accountability of the democratic process. Or the other could be simply that you didn't think these qualifications were unreasonable from your point of view. So how are you thinking about parsing out these specifics when you're actually writing these opinions? Like, what are the discussions you have with the lawyers presenting the arguments or your fellow judges? Because this is the minutiae which really starts mattering, right?
So far as the discussion with the lawyer, it's an open court. Everything was an open court of resolved. And insofar as the colleagues are concerned, both Lok Prahari and Rajbala, my colleagues accepted my view of the discussion. And then the distinction, you say that I was more expansive in Lok Prahari. It all boils down to this. Rajbala, for somebody to contest an election, the panchayat election, the local body election, there are certain restrictions imposed by the legislature. The question is whether the legislature was competent to impose those restrictions or not. And whether somebody should be an 8th class pass or 10th class pass is a matter of opinion. And at least till then, the Supreme Court consistently held that the substantive due process test is not. Later, of course, Justice Nariman took a different view in another matter. I don't want to comment about that. But till then, at least. And second thing, well, just hypothetically, I could deny the authority to the legislature on an interpretation as I understood the Constitution.
Yeah.
Question is whether the nexus is so absurd and what is the purpose sought to be achieved. Since you said what happened in discussion, when I first heard that, when I was hearing the matter, Rajbala's matter, I asked the Mr. Mukul Rohde, who was Attorney General, who was appearing for the state in that matter.
Okay.
The state of Haryana.
Yeah.
In fact, I asked Mr. Rohde, my initial reaction, of course, was that, look here, there are a lot of poor people in this country. They cannot, maybe most of them, are we not making it a very onerous condition for them to contest an election? Then Mr. Rohgi made a statement, which was not yet on record. Later, they filed a next day, they filed an app. He told me, he told the court rather, there is a scheme in this country. If somebody wishes to build a toilet, the government would give a grant. It started sometime in 1980s. The starting at that point of time, it was 500 rupees. I remember his word. You know, we are not talking about a five-star toilet and a five-star hotel, a functioning toilet.
Yeah.
And 500 rupees was, and at the point of time when we were hearing Rajbala's case, the grant, if I remember right, I think I recorded it in the judgment. It is 12,000 rupees. It was a grant. It was not a loan.
Yeah.
If somebody wishes to build a toilet, in fact, I asked Mr. Rodgi, Ms. Rodgi, I'm a judge of the Supreme Court. Until you mentioned it, I didn't know about the existence of this scheme. How many people in this country would know this? Some officer is briefing Mr. Rodgi, sitting behind some officer from Haryana. He jumped up and whispered something into Mr. Rodgi's ears. And then Mr. Rodgi told me that, my lord, I am informed that a substantial number of people have availed this benefit of this grant. Then I said, can you file an affidavit explaining the details? Next day, an affidavit was filed on the state of Haryana. Subject to correction, my memory is. I think I recorded all this in the judgment, not the conversation part of it, but the content of the affidavit. There are some 8 lakh below poverty line households in Haryana. Some 80% of those households had availed this benefit, this grant from the government. They filed a sworn affidavit. And I don't think everybody would give a false affidavit on that. No, after availing the facility, whether the beneficiary really built a toilet or used it for watching movies or some other thing, I'm not concerned. So you can't say that the legislature took all these things into consideration and made a law. Now, suppose similarly coming to the educational qualifications, in fact, I very deeply thought over the patterns. Now, suppose if the legislature has the right to impose such restrictions, what is a reasonable condition is a question.
Yeah.
Suppose if the legislature were to say that anybody who is aspiring to contest a panchayat election should have a PhD, could it be approved? Or only Nobel laureates could contest a panchayat election. It becomes an impossibility because no election can be conducted. That kind of extreme cases, no. Obviously, no. It is not the question of due process, the invocation of due process law, but simple irrationality having regard to the situation. Prescribing an 8th class qualification, no. Whether educated people are more responsible in conducting the public affairs or not is a matter of opinion and value judgment. I don't want to go into. But is it within the power of the legislature or not was the only question in Rajbala. Well, at least I didn't see any unconstitutional exercise of power in that. And my colleague agreed with him. But I know it was one of my very bitterly criticized judgment, I know.
So when it comes to Lok Prahari, how come you don't interpret non-disclosure in as simple or strict way? Why does that have to be read in along with other kinds of corrupt practices or the context of what's happening in the country? And so,
Reason is simple. In Rajbala, there was a statute. Lok Prahari, there is no statute. If you check up the judgment, at the end of it is said the election commission, the power to make regulations and this thing, and the rule-making power under the RP Act that could be invoked to make appropriate statutory backup for the listing. So I was not legislating there. And then there are 2 earlier judgments about dealing with these things, this question.
Yeah.
The disclosure of assets and liabilities, and then there is a next step.
Yeah.
It's not that I was inventing new law. There's already a law declared by the Supreme Court. That calling upon, where was the requirement earlier in the law? It was not there. Interpretation of the Constitution and the relevant laws the Supreme Court had held. That the public have a right to know who are these people who are contesting. After knowing fully, see, for example, people's choice. Say a particular, I don't want to name somebody who's dead and gone. A particular chief minister was held guilty of corruption. Election was gone. The chief minister went to jail. In a consequential by-election to that very seat, a candidate fielded by that particular chief minister won with some extraordinary, some 5-6 lakhs majority. People still want to vote to the party or the particular leaders. It's the people's choice. In fact, I remember Winston Churchill used to say, I would rather believe the foolishness of the people than the wisdom of unelected judges. But he also cautioned people want to vote such people, they should have a right to vote. But that does not make folly wisdom, he says.
So, speaking of unelected judges, I want to talk about two very important, constitutional bench cases where your, in one instance concurring and one instance dissenting opinion have now set the stage for this debate. So, the first is Indre Justice C.S. Karnan, which was this quite an unfortunate thing that was going on. And as you point out, there's no real mechanism that we have within our constitutional structure other than impeachment to deal with severe misconduct of a judicial officer at the High Court level.
Just before you complete the question, let us be clear about it. I never said the conduct of Karnal pre-notice stage misconduct. I said that because he never entered his defense, he refused to argue the matter. In fact, I repeatedly requested Mr. Karnan from the bench, please enter your defense. He said, no. The man was very dramatic. No, you lost him. And he said, oh, it's unpleasant to recollect this thing. But I personally requested from the bench, please enter your defense. But I recorded in the judgment was the objection about that man, that he made all kinds of allegations against his own colleagues, his chief justices of that particular high court, so and so. He wrote letters to the president, prime minister, and all. But I observed in that if somebody believes that a chief justice or somebody, a judge, is doing wrong things or corrupt, whom else will go and tell except the president and prime minister of this country? Whether the allegations are true or false, these are all matters to be inquired into.
Yeah.
All that I felt in that case, me and if I remember right, even Ranjan Gogol agreed with me, that his post-notice conduct, he went on issuing orders purporting to be judicial orders sitting in the High Court, restraining the bench from proceeding with the matter. Supreme Court went. In the hierarchy of the system, if the High Court starts issuing this kind of orders, it is nothing but interference with the judicial process. That's what I found contemptuous. Not his conduct, alleged conduct prior to that. And for your information on the lighter wing, that man issued about after my retirement 2-3 notices I received saying that I have imposed penalty of 2 crores on you, please pay it to me.
No, I think it's quite clear when I read your judgment and the overall judgment on how complicated it is to parse out the misconduct of any judicial officer, especially someone like C.S. Karnan. And there was lots of things going on, right? Things he said as on the bench, things he said in court, things he started writing in letters and so on. And I don't want to get into that. But the very interesting part of that opinion to me is you almost anticipate what is going to happen with the higher judiciary in the next 10, 12 years. And you very clearly specify that there needs to be not just a code of conduct, but a mechanism to deal with misconduct when it falls short of impeachment.
Well, misconduct may be too strong a word. Of course, there can be case of misconduct also. Too strong a word. Conduct which is not consistent with the dignity of the office. Well, there's once again a matter of opinion, right? The people who believed that when I held the press conference, it was not consistent with the dignity of my office. And there can be views and views about it. There are views, I know. Very big, eminent, big people held that I ought not to have done it. Well, these are all matters of opinion. Misconduct perhaps is too strong a word in the context.
Well, they did hold him in contempt. I mean, the bench, this opinion held him in contempt.
I'm not talking about that particular case. Say, for example, let us say a particular judge is absent 3 days a week from the court. Maybe he is within the limits of his available leave and things like that, but consistency. It may not be misconduct, but it is something which requires to be addressed.
Yeah.
either by counseling or maybe in a given case he has some genuine health problem. Everything need not be misconducting that, because that word has a certain amount of odium attached to it. That's what I'm
Yeah.
saying.
No, I think that's a very fair clarification. So
Mm,
now, if I limit myself, let's say, to misconduct and not to these gray areas,
mm.
you really anticipated this problem of, corruption within judiciary, which we now have many, lots of speculations and instances that, that does take place. You tried to warn us in the Karnan opinion that we need a system.
More neutrally, saying the system might get into trouble. That's what I said. So what kind of
Yes.
trouble is something? Well, and what happens once the system gets into trouble? What will happen to the republic and what will happen to the people and constitutional governance is a matter of fairness. That's what I
Yeah.
said.
Yeah, but you also said something important, which is that the correction must come from within and the correction must be preemptive. I think that's the part that I want to get into here. So, in the Karnan case, which comes before the NJAC amendment or the opinion and your dissent and so on, it already seems like you're like, look, this is a problem, whether it's a single case or a recurring matter. We need some system to deal with it. We have a particular institutional framework of judicial independence. And if we are responsible officers of the court within that particular framework of judicial independence, the sunlight must come from within, so to speak, right? So you're quite clear on that in the Karnan opinion. Now I want to come to the NJAC opinion and the dissent. There, the dissent actually, I think this won't surprise you. It's one of the favorite things that you've written that I have read and really appreciated, because you parse out 2-3 things very clearly. One is that there's a difference between judicial independence being part of the basic structure versus one particular method of appointment being part of the basic structure. And I think this is a very important constitutional distinction, and it gets conflated all the time.
Mm. Mm.
So that part of it, can you walk us through, is this a genuine conflation or are people just hand-waving so as to keep things within the judiciary? Your view seems extremely reasonable when I read it, that, there's more than one way to achieve judicial independence. This collegium system, which has been read in through a couple of, court cases in the 90s, cannot possibly be the only way. We did appoint judges before that. So, and we can't go on to say they weren't independent. So why is there this conflation in the judiciary? How much of it is just, sort of self-interest? How much of it is genuine fear of executive interference? So what was happening when all of you were debating and writing that NJAC judgment?
I'll confirm myself to my opinion. If you read it carefully, I'm sure you would have read it. It is sought to be interpreted saying that I tried to support the government. It was an amendment passed unanimously except one vote by the parliament. And then it was not this government, that government. It was the parliament unanimous except one vote, Mr. Ramjit Malan.
Yeah.
Politicians are such people in every political party. They talk whatever is convenient to them. Just in the context, I'll tell you.
Yeah.
When Puttaswamy judgment was delivered, in fact, all the trouble started initially. It was listed before me. I had it in a bench of 3. I referred it to a larger bench because of some. You remember that whole story.
Yeah. Karak Singh and everything. Yeah.
Correcting and everything. Finally, nine judges reference also was made by.
Yeah.
Then 9 judges said we wrote the opinion. The privacy judgments, so things started with this Aadhaar and the proposal. With that, the privacy, that question cropped up. And the whole bill was mooted by a political party which was in power earlier.
Yeah.
And a political party which came to power later, which is still continuing in power, pushed through that bill.
Yeah.
And it was the Attorney General who argued before me, before the 3-judge bench, that there is no fundamental right of privacy under the Constitution on a stray observation in correction.
Yeah.
He said there is no fundamental right. And eventually, the 9-judge bench declared there is a fundamental right. The interpretative process by which each one of us who wrote different opinion, but the conclusion we reached. And you check up the papers next day, both the political parties claim that their stand stood vindicated. This is how they can talk. You can check up the newspapers the very next day after the judgment.
Okay.
Both political parties, the party which mooted the Aadhaar bill initiative, the government which opposed tooth and nail the assertion of getting a fundamental, correcting if you remember, is 8 judges. That's a
Yes.
vague reason.
Yeah.
Those days, there are a few cases where they were written by benches consisting of even numbers. There are some judgments written by 4 judges, correcting by 8. It must go before a 9 judge bench. That was the argument of the attorney. I joked with my colleague on the bench with me on that day, Justice Bob Day. Thank God you're not asking for a full court because when correction was written, the 8 was the full court. The strength of the Supreme Court itself.
Yeah.
Thank God the AG is not asking for a full court. So therefore, NJAC, I never said hand over the appointment process to the government.
Yeah.
All that I said is earlier judgments experimented with the constitution and created a system of collision. Here also, what was done by the Supreme Court. So if you read the earlier judgment, Supreme Court Advocates case 93.
Yeah.
Justice Verma said, we are only trying to formalize an existing practice. Every successive Chief Justice had consulted his colleagues. Any conscientious Chief Justice should consult his colleagues. Suppose I come from a particular state, recommendations are coming from another state. Even if I were to be the Chief Justice, I won't know, I may not know mostly about the candidate. Wisdom requires that you consult somebody who knows it. Look here, this name has been recommended. What do you think, brother, about this name? That's the only way to ascertain. That's what the successive Chief Justices were saying. That's what Justice Verma wrote. As a matter of fact, it was happening. It was a discussion which of the earlier Chief Justices whom to consult. Now the judgment says consult the first four initially, later became 5. You remember all that development.
Yeah.
They said put it on a more concrete basis.
Yeah.
Instead of leaving it to the exclusive discretion of the Chief Justice. Then that experiment, it was the unanimous opinion of the Parliament. It didn't work well. And I shared that opinion personally. Well, I don't want to go into the details now.
Yeah.
There are questions about how the system worked in the implementation. If you remember Justice Verma's judgment, all this experiment, he said, it's not to be conducted in the spirit of winner takes all.
Yes.
It's a joint effort by both the executive and judiciary to find out the best for the bench.
Yeah.
But in how many cases did it fail? Not that every time it failed, but number of cases is big fail. Not the best always were picked up. I can give you innumerable instances of the best. No, that's not the point. Now, all that an alternative model is proposed by the Parliament sitting as constant assembly. Still, the judiciary had 3 votes in this out of 6.
Yes.
And the old second judge's case continues to hold the field. So any 2 determined judges could stop the elevation of a unwarranted candidate.
Yeah.
Maybe none of them could have brought their own kith and kin because there are others who. But stalling, any 2 judges could stall if they honestly believed that the candidate is unfair.
Yeah.
I didn't find anything wrong with it. In fact, the whole thing was about the participation of civil society and 2 members nominated.
Yeah.
That repeatedly, Justice Kerr asked the question, whom are you going to nominate? Attorney General refused to come up.
Yeah.
Now, arguments say, because I didn't say this in the court, arguments say it. If the nomination is to be made by whom? The government, leader of the opposition, and Chief Justice, 3 people. If you're not willing to trust anybody in the country, you don't trust the wisdom of the Prime Minister, you don't trust the wisdom of the leader of the opposition, you don't trust the wisdom of the Chief Justice. Oh, no. They'll nominate all kinds of people. Therefore, this is detrimental to the. I said, this is totally illogical. I don't think any system can work with this kind of. So, therefore, I said, nothing wrong. No system can be perfect. Democracies are always experiments.
For me, more than the perfection part, what I find really baffling about the NJAC case is it's a fairly narrow question, right? Whether a particular constitution amendment fails the basic structure test or passes the basic structure test, right? What is included in the basic structure in this particular instance is judicial independence. So, to me, it seems like four of your colleagues said that the only way to achieve judicial independence is if the judiciary is in some sense self-appointing, as it has been for a while, and has primacy, seems a little bit strange. Right? So, what I mean is, when I read your dissent, it seems very odd that that's the dissent. Why is that conflation taking place?
That is the law declared by the Supreme Court. You and I are bound by it. What do we do about it?
No, not what do we do about it, but why is this going on in the court? Like, is it just naked self-interest? In which case I am an economist. I understand that very well. I understand naked self-interest and wanting to appoint kith and kin. And I'm like, okay, that's why the system is going the way it's going. Is it a particular kind of paranoia? Is it being triggered by emergency? Why is there this conflation?
One second. I don't agree with it. That each one of them is motivated with the idea of picking up their own keeping. No, I don't even contribute to that. That situation is so bad. The point is, as I see it, the amount of peer pressure, a very eminent counsel, a battery of eminent counsel, appearing and saying that, look here, this is going to destroy the institution, so on and so on. And somebody who had argued the second judge's case and wrote later a case which I argued one and lived to regret, turns back and says, no, that should continue to be the law. At least I can say this much. As Jetmalani appearing, whom I hold in very high regard. In a couple of cases I worked with him, I really admired his capabilities and his independence. So he said the presence of law minister is deleterious to the independence of the judiciary. That was the sum and substance of the judge. Law minister was one of the members of the NJAC.
Yeah.
In fact, I asked him in the court, Mr. Jetmalani, you yourself were the law minister some point of time. What are you saying? And of course, he said something which I don't want to repeat. Yeah, but this whole thing it went beyond all logic. There are personal beliefs and personal horrors which played a greater role in these arguments and conclusions.
That actually I find more disturbing than my interpretation. Because my interpretation of naked self-interest, then you can understand what's going on. This just seems like some kind of groupthink or clique or club that is impenetrable. That seems so bizarre to me.
There is a lot of confusion. I don't want to use any other expression. You remember that other case about judges, that letter of the law minister which triggered off the litigation.
Is this Gupta? SP Gupta?
I think Gupta. I'm becoming old and forgetting things now. Then law minister wrote a letter asking, remember, asking the chief justice to... The argument before the Supreme Court is, then of course this whole argument of judicial independence of judiciary, the standard story. Then one argument is the fact that the Constitution mandates consultation with the Chief Justice, that is the greatest safeguard to the independence of the judiciary. Justice Bhagavati, who later became the Chief Justice, who was a legend in his own lifetime, he wrote, however exalted the office, it is not a guarantee for the independence. He said all the 16 transfers of the emergency were in consultation with the Chief Justice. About which the whole nation went on shouting post-emergency, oh, it was all a vindictive activity by the then government. That's what Bhagavati wrote. There is no guarantee. The office may be exalted, but the mere fact that the Chief Justice is consulted is not necessarily an insurance of independence of the judiciary.
Yeah. No, to me, it honestly seems like groupthink because it seems very odd that yours is the dissenting opinion in this. The whole thing seems a little bit strange to me. And the other reason I think it's a bit clubby or cliquey is you've also been excluded from a number of benches after some of your famous dissents. In a way that I'm not the first person to observe this, nor have you spoken about it, but other people have written about it.
I still get my pension, mercifully. It makes no difference to me. I wrote judgments in whatever cases came before me.
Okay, so let's switch to Puttaswamy, which is, I think, a really important case of your career and has had enormous implications after. So, in terms of background, as you already mentioned, this had to do with Aadhaar, what started as a pilot project and then ended up becoming a much larger project that would cover all of India. And it started originally as a welfare enhancing scheme, that is a way to make sure that the correct recipients got their benefits. But of course, very quickly, went beyond that realm because the technology was so powerful and the platform was so powerful. And you are the person who referred it to a larger bench, and Puttaswamy was 9-judge bench. My first question is, at the core of it, it seems like all of you agree there's a fundamental right to privacy. There's no dissenting opinion in
No,
Puttaswamy.
fortunately, no.
But there are lots of concurring opinions, right? What exactly goes on during these discussions in terms of what are the nuances that you agree or disagree on, that there must be so many concurring opinions?
There was nothing. There was only one meeting. And then judges who were inclined to write, which was desired to write. Every judge has the right to speak for himself. When a judge says, I want to write my own opinion on the matter, okay, then you will be separated and will be examined later. But that's a different story. Afterward, there was no discussion.
So, to me, there are three really important opinions. I mean, there are lots of concurring opinions, but one is, of course, Justice Chandrachud, who wrote the majority. Then there is Justice Kaul, who wrote one of the concurring opinions, and you, who wrote one of the concurring opinions. And to me, these three put together have sort of set the stage for what comes after. So the way I interpret Justice Chandrachud's opinion is it's setting the stage of privacy in a very expansive way, because they're anticipating what is on the docket after this, right? So, we know there's Johar coming after this. There are these other Aadhaar cases coming after this. So there needs to be this sort of catch-all sense of how broad can we make the right to privacy, right? So that's sort of how I interpret that particular opinion. You're smiling, but that's how I think about it.
What else do you want me to do? Want me to cry?
So, of course, there is, the three-pronged test that Justice Chandrachud gives. I don't want to be uncharitable. There's a very clear test of, the legislative aims, the proportionality, and so on that he outlines. Justice Kaul, he creates a four-pronged test instead of a three-pronged test, and I don't want to go into that sort of minutiae. But he is really thinking about what the technology can do. At least that's how I interpret his concurring opinion. So to him, this is a new technology that both, the legislature and the court are facing. The old methods of protecting fundamental rights and privacy may now start faltering unless we have clearer lines when faced with this new and very powerful technology. And so that's how we need to think about the checks and balances. Yours, I found completely different in the sense that you are I think, if I'm not wrong, the only person, or at least the only person to say this strenuously among all your colleagues, on the need for the legislature to resolve this in some meaningful way, right? So you're very clearly stressing that we can't make this up as we go along. There needs to be a legislative framework, and you sort of anticipate the Aadhaar Act and, of course, the DPDP, which is now, followed since then, and so on and so forth. But you have also managed to give us a test on how you would judge that statute when it comes to pass, right? So you lay out what would be the restrictions under 14, what would be the restrictions under 21, and so on and so forth. One, it just seems quite different from what the others were doing. So, if you can comment on that. And two, what were you thinking? What were you anticipating? Or clearly all of you are anticipating different problems. So that's the question I have now that I have the opportunity to speak with you.
I can speak for only myself. See, there is a little background to this. Essentially, I was a student of physics before I entered the law college. Of course, I was a very bad student of physics, therefore I stayed into law. Otherwise, I would have pursued this thing. But nonetheless, I was still a student of physics. Some basics of physics I knew. Second thing is, if you recollect, I was a member of the bench which declared 66A Information Technology Act
Yes.
unconstitutional.
Yes. Yes.
Just Nariman ruled to defend the judgment. In fact, I heard that case twice over. Initially, one sitting with Justice Bobde. Then the summer vacation intervened and the bench broke, and then a new bench came. Once again, I had to we had to hear it again. Twice over, I heard. And a lot of younger generation lawyers argued that matter. Senior advocates came and, of course, cited half a dozen Supreme Court judgments. And then the nitty-gritty of technology part of it. That was certainly not for people of my age. It is all Greek and Latin. But the younger generation lawyers had better information and better knowledge about this technology, the interface with technology. I heard those things. When I was hearing the matter, rather, we were hearing the matter, that 66A, some senior advocate was making some submissions. I don't exactly remember what aspects, but it has implications of technology. He was, senior advocate was arguing. A young girl, somebody like you, was sitting in the second row. When the submission was being made, she was violently swinging her head in disapproval of what was being submitted to the court. Sitting there. I noticed it. And I stopped the senior counsel and asked the girl, young lady, apparently you were not approving the submission. Then she panicked because suddenly when the court asked her, and she said, "My lord, I'm sorry." I said, "Don't panic. I think it's going to happen to you. But I do realize that you are not in agreement with you may be right to be learned senior counsel, you may be right, but I would like to know because we youngsters know something about this technology." Then after even just Nariman said, yeah, come on, tell us what is it. She picked up the race and then she gave certain inputs about technology and it looked at from that point of view how the submission may not be correct. That's right. So this is the background. And then
Do you remember the name of the young lawyer? This is Shreya Singhal case, right?
Shreya Singhal's case. Some young hardly
Sure.
2-3-year-old at the bar, perhaps.
Yeah. No, just curious.
No, but all this was working in my mind. And second, of course, my own general reading. Did you read Noah Harari's 21 Lessons for the 21st Century?
No, I haven't read that one. I've read his other books, but I haven't read that one.
Please read it.
Okay.
He says artificial intelligence and biotechnology revolution is going to change the world. By 2050, it will be impossible for us to imagine how this world is going to be. Because fortunately, I may not, 99% I won't be there. I would be, even if I'm alive, I would be 97 by the 2050. Fully, I may not be there. But you people will have to face it. And he gives examples in it, how it is going to be. He just gives one example. He says driverless cars will become a norm. By 2030 or 35, it will become a norm, he says. And then what happens? The consequences, some of them which he gave. Driving as an occupation becomes redundant. That will result in a lot of employment problems. A lot of illiterate boys and girls nowadays at least can become chauffeurs. That option would be gone. That can create innumerable other consequences, unemployment and whatever consequence. Apart from that, one more thing he says. When somebody is driving a vehicle on the highway at a high speed, and he notices a child crossing the road at a distance, let us say half a kilometer away, and the car is full, 4 people in the car, the driver's mind makes a calculation as to whether the car would hit the child, which the speed at which the car is going, and the child. But there are a number of imponderables in this. The child might suddenly change course. These are all questions for which the human mind calculates and that takes its own decision. One question is, if it is inevitable to hit the child, even according to the human mind's calculation, there's no way of stopping unless applying a sudden brake, which may result in a crashing of the car and killing all the people in the field. One life against four lives. One life of a child and four old people like me. So the answer to this question depends on the ethical value system of the driver. Now, in a driverless car, it depends on the program written and who wrote the program and the person who wrote the program for the car's computer. So this leads to complicated lawsuits. Or just imagine, he gives it as an example.
In your opinion, again, Puttaswamy case is really long, so forgive me if I'm misremembering some small details, but you're quite specific on the kinds of concerns you have. You very specifically say people have the right to privacy and no infringement in terms of what they eat, who they associate with, and their immediate life, and so on and so forth.
Most basic aspects of privacy.
Most basic, yeah. So you are not expanding and going into some kind of, futuristic world where the technology can damage us in, any particular way. It seems like the thing you're most concerned about is some kind of low-level state surveillance and any kind of misuse, potential misuse because of state surveillance. The kinds of concerns you just mentioned about, private parties and their ethical complications, I see a little bit more of that in Justice Call's opinion, right? He's a little bit more concerned about private parties. Right. So when you were talking, in your opinion, what are some of the big surveillance concerns you have when it comes to privacy, right? Because your other brothers were mostly talking about privacy in terms of dignity and agency and a slightly different view. And here you are very clearly talking about what are the kinds of restrictions or boundaries within which one simply can't interfere with an individual. So what were the things you were worried about? Is it like cow slaughter ban and, people getting lynched for eating beef? Like, what's going on?
Not specifically, but maybe each one of these factors must have worked on my mind. Judges are not immune from all information. Each one of these pieces of information must be working consciously or subconsciously on the mind. And some of these things are the most fundamental things. What I eat is my choice. Having concerns of health, where the state can impose, look here, this is not a healthy food, that's a different story. But for other reasons, if suppose somebody were to say, I don't like your eating chicken. So somebody were to tell me, you don't eat, I said, who are you to tell me? So what are the most fundamental activities of a human being? Food is one thing. And second thing is certain personal preferences. Whether I want to wear a shirt and pant or a dhoti or a jubba, my choice. Okay, if you are entering an armed service, there's a subject to the discipline. You don't enter, otherwise you don't want to go there.
No, but what's the connection between the kind of surveillance you were worried about when it came to Aadhaar and these questions? Were you...
See, the concern is this, the kind of submissions made and the potential that it could face. See, for example, one of the arguments, if I remember right, it's damn Diwan, I have subject to correction. Tomorrow, the minute surveillance is permitted, for whatever reason, the minute you switch on your mobile phone, everything is recorded. What time you woke up, what call did you make? And then the minute you get into the car, it is recorded. Where are you headed to? How many checkposts did you cross? All this kind of information was placed before the court. They said these are all the possibilities. And effectively, nothing would remain private, your activity. Of course, class, we have nothing to hide. Why are you so worried about it? It's not that. I have nothing to hide. It's not. I don't want to disclose. Even if it is nothing illegal or immoral or obnoxious, I still would like to be a private person. Why should anybody know about it? Why should the state know about it? Why should anybody know for that matter? There are certain things which you would like to disclose certain things to your own parents, your own partner in life, your own children. I'm not talking about morality part of it. There are always things which require some kind of.
Sure.
So therefore, anything which gives an unlimited access to the state and its authorities to see through your personal life would be inconsistent with the constitutional guarantee of privacy.
Have you had a chance to look at the DPDP?
I retired 7 years back. I don't have any good reason to look into all these things.
No, it seems like you anticipated that that should follow, and it has followed.
That something like this is going to come, I had some idea about it. In fact, a lot of people, those days, youngsters, unknown people, sent me mails saying that, this is going to happen, this is going to happen. Those people who are working with these things, a lot of people sent it. A lot of information, most of which maybe I didn't fully grasp the implications of that information. But a lot of information was before. In fact, some student in Oxford, I think, at that point of time, who had earlier clerked in the Supreme Court, not with me, but some other judge. And she got to know I was on that bench. She sent me a paper which she penned dealing with some of these aspects of privacy. A lot of people like this. But neutral material.
Mariam Kamil?
In something. Yeah. Now that you mentioned the name, she clerked with Justice Kabir. See, normally, every time, every judge, lot of warranted, unwarranted information comes. People send anonymous letters, pseudonymous letters, all kinds of things, everything. No, but in these cases, it's a neutral information from informed sources, people who are serious about these things.
So, one other aspect in your judgments that I want to pick on is, again, it's unfortunate that this should set you apart from others. I would think this is the norm. Again, this adherence to procedural fairness, right? So I see this in your opinions across a number of different cases. So whether it is, not Constitution bench, but I'm talking about the Tamil Nadu MLA suspension, you somehow managed to walk that line of staying within the realm of separation of powers, and the judiciary must not intervene in legislative matters and the power of the speaker and so on. But there has to be very clear adherence to procedural fairness, and videotapes must be produced and so on.
Really. Otherwise,
You say naturally, but no one else is writing these opinions.
What do I do about it? What do I do about it?
This has now become a little bit rare, right? We don't see procedural fairness opinions. We don't see these strict interpretation opinions anymore.
See, all administrative law, which we study very passionately, what is it all about? It's about procedural regularity.
I guess what I'm asking you is, what is happening to Indian jurisprudence, especially the way it's playing out in the Supreme Court, that we are moving farther and farther away from the core principle?
Shruti, without meaning any offense to anybody, I think the employment of the word jurisprudence in the context of Indian judicial system is what is the big jurisprudence? Please tell me. No, I'm serious. I'm serious about it. See, the law of precedent takes all the simple problems of jurisprudence. I'll tell you something which happened in the court. I was a young lawyer. I was appearing for the then Chief Minister of combined Andhra Pradesh, late Mr. N.T. Ramarao, in an election petition. The election was of 1983. Things happened, a lot of things happened in the next 2 years in Andhra Pradesh. His government was pulled down by somebody, and then again he came back. And then Mrs. Gandhi died. There was a Lok Sabha election, followed by another assembly election in 85. Within 2 years, the assembly was dissolved. It's all part of his recorded history. Challenging his first election in 1983, there was an election petition. I was advocate on record for the Chief Minister, N.T. Ramarao. We decided we'll have a senior advocate for trial and argument. Preliminary. I raised the preliminary objection based on Karunanidhi versus Hande 1983 Supreme Court. The proposition is election petition, true copies of the election petition must be served on the respondent. What is a true copy? Is the question. And in my opinion, that particular election petition copy served on the returned candidate N.T. Ramarao was not a true copy of what was filed in the court. So I raised a preliminary objection, but before the objection could be decided, a lot of things happened. And then one judge before whom the election matter was listed retired. A lot of things happened. And finally, it ended before some other judge. By then, that assembly was dissolved. Then the judge asked me, what the counsel, do I have to really try this matter? That assembly is over. I conceded you'll have to try the case because there's an allegation of corrupt practice. He proved the man is liable to be disqualified. I conceded. Then the judge said, you're fair enough, but then I have my own doubts because the disqualification was automatic prior to Mrs. Gandhi's amendment, that 42nd Amendment, 6 years. Now it is discretionary in the hands of the President and Election Commission. So there's nothing like a compulsory disqualification. And at any rate, he had a doubt about it. He said, I'll order notice to the Attorney General. I said, well, court's choice. Court ordered notice to the Attorney General. Mr. Parasharan came. After a couple of days, he was busy. He came. Forget about what transpired. And all this. Anyway, finally, he also said, you have to, told the judge, you have to try it. There's no choice. Then at the end of it, the judge asked Mr. Parasharan, there's one more question I want to ask you. Mr. Parasharan, two judgments last year, one in Karunanidhi, one in Madan Mohan, the same year, 1983. Madan Mohan was the former health minister of Ola in Andhra Pradesh state. The judge said both the judgments I find there's a huge conflict between on the same proposition of law. What am I supposed to do sitting in the High Court when the Supreme Court hands over two judgments in the same year which are contradictory to each other? Then Ms. Parasharan gave a devastating answer. He said, your lordships are very lucky. There are two judgments before your lordships to choose. More often, I'm confronted in the Supreme Court with the situation nowadays where I rely on the earlier part of the judgment and my opponent relies on the later part of the judgment. He said it in the court as Attorney General. So what is the jurisprudence you're talking about? This was in 1983. Parasaran is still there. The judge is no more. He passed away. I am there. Mr. Parasaran is still there. I don't know whether he remembers this incident or not. We can check out it.
One other case where you wrote this dissent, this is Muhammad Arif. This is the death row case. Again, when I start looking into it, it seems a little bit odd because it's a very narrow question, right? The narrow question is whether it can come up again for review. Typically, these reviews come up before the same bench that decided the original case. And the very narrow question is, does it have to be held in open court or is it an oral proceeding in the office or the chambers? This became quite a big deal. These are enormously long opinions written by your colleagues. And you are again the dissent in this. What is it that the others were concerned about? Is the major concern or panic that the judiciary is now just so overloaded, there's so much pendency, and death row cases in particular, we should just never be wrong. And, if we have to break procedure or precedent and err on the side of caution, then that's the way we go. I'm not able to coherently understand what their fear is jurisprudentially or emotionally. So what was going on at that time? Because your opinion is extremely clear. Basically, your opinion is do as we have always done. That's it. That procedure seems to have functioned just fine. There's nothing new that you can add by adding one more review process in this particular instance.
You do it one question. That rule which required the reviews to be heard in camera was challenged and upheld by none other than Justice Krishna Iyer. Perhaps I don't think anyone of you is more liberal than Krishna Iyer. At least that's my view. You may have a different view. He said we gave reasons. Permitted. Point is, as I mentioned in the judgment, first of all, there is no right of appeal in death penalty matters, barring a case where it's a reversal of the trial court's acquittal. There is no constitutional right of appeal.
Yeah.
By way of a special petition, you come here. Two judges hear the matter, decide, and then a review. And what is all this? If you are not willing to trust anything, then if you are so suspicious about the quality of the hearing by your own colleagues earlier, then what you should do is check up your recruitment policy, not a review, open court review again. And then what they say, three judges.
Yeah.
Three judges. If I say this today, they'll pounce on me saying, oh, this man is pointing fingers at the court. What does it mean? You're creating an intra-court appeal.
Yeah.
In which case, amend the rule. Nothing stops the court from making a rule saying that, okay, let all these matters be heard by 5 judges or 7 judges. If you think 7 judges' wisdom is better than 2 judges, wonderful, nothing wrong with it. But why this process of review? And then finally, what happens? Dependency increases with all this. And a few weeks back, somebody sent a WhatsApp message to me, giving the whole story of Arif's case. In 2002 or 3, the incident took place, how many years it took for the investigation, trial, refer trial, and Supreme Court review. And a very caustic remark. Some 20 years after killing 3 Indian soldiers, Muhammad Arif is still alive. And thanks to Indian judiciary, there is a message. Somebody forwarded it to me. I simply, somebody who's known to me sent it to me. It's a wrong address. The dissenting judgment in Arif's case. Not that I took any great pleasure or pain in writing that case. I have nothing with Arif. Yeah, but it is, don't, you can't blame me for this. This was widely circulated. I think even on YouTube, somebody was speaking about it. Nowadays, you have a mobile phone. Of course, there are also people blame me because of this Instagram 66A. All these things are happening. I said that's the price which I pay for my liberty, smaller price. You have a mobile phone in your hand, you can post anything on the YouTube.
So, when it comes to cases like Muhammad Arif, I don't think the opinion that Justice Nariman wrote is incomprehensible or something like that. That's not what I'm alluding to. What I couldn't parse out was what was the source of systemic bias or distress that they were trying to correct, right? So one possibility could be these are extreme circumstances, right? They're very political situation of this particular matter. This is not just a standard death row case, right? So this is very specific. There are soldiers involved. There are people from minority community involved. And we need to be a little bit extra careful and extra sensitive because we are not sure if the...
If that is the case, the logic should be more closely tailored logic. No, the judgment applies to every majority, minority, man, woman, anybody. If that is the basis on which that judgment proceeded, or the idea behind, then it would have a more closely tailored judgment. I'm not commenting on my colleague's opinion.
No, I totally understand.
I'm only discussing, entering a discussion with you on what you said. No.
Yeah, so I'm also not able to entirely understand what is the bigger problem that they were solving for. I mean, I understand that the core level problem they're solving for is error, and we really don't want error when it comes to a death row case, right? So that's a pretty straightforward thing. But there's a broader concern. There's a systemic concern about the judiciary.
I understand. Everybody becomes a little thing, which life which is being extinguished. Let's be more cautious about it. It's irreversible. Irreversible. Understand, fine. Maybe people may think that I'm insensitive to this kind of thing. Well, it's open for people to draw that. But point is, you have to trust the... See, you remember, I quoted it in my NJAC from Lawrence Tribe's case. He said, remember that quote, I do not consider the judgments of the Supreme Court to be synonymous with constitutional truth. A court which held slaves to be non-persons, separate is equal, so on and so forth, can hardly be final or infallible. But the profundity of the balance of scholarship comes in the next sentence. But such passing finality as the judgments of the Supreme Court have is essentially a compromise between order and chaos, it says. So you have to trust somewhere. Two of your colleagues. No. If you think the wisdom of two colleagues is not good enough, amend the rule, make it 5 judges in every case. This ad hoc decision making.
Yeah, so I think that's, on this we're on the same page, which is too many things in the court happen on an ad hoc basis and, we're making it up as we go along based on the particulars of a case as opposed to a broader rule.
Maybe tomorrow another set of 5 judges may think maybe 3 is also not good, 5 judges are required. Do we go on like this? When we're talking about jurisprudence, these are my problems.
What is your view of how you think more broadly about dissents? Because you have been called the famous chief dissenter of the court and you have some interesting monikers attached to you. Do you see them playing an important role in the way the jurisprudence evolves? Do you see these just as we need to put forth our arguments at that point and see who runs with it in the future?
If I have taken a note, but that's not any judge who takes it, that he'll decide it to the best of his ability to uphold the law and the constitution. The law and constitution as you understand it. My understanding did not be right, it may not be perfect. Or it is right and it's perfect. I don't know. It all is a matter of opinion once again. And what if when it is found to be mine is a minority opinion, tomorrow somebody it may become a majority opinion on a future date. A view which was held for 50 years that all rights of election or statute creatures of statute, well, now changed. And it's the obligation to decide in accordance with the constitution. But the parenthesis is as I understand it. I was not asking for attention when I wrote a dissenting judgment. Certainly not. I was not looking for the headlines next morning. That's how I understood the constitution. I thought I owed a duty. I wrote.
No, and it was a pleasure to read some of them. So thank you so much for doing this. This was such
Thank
a
you.
pleasure. Thank you for speaking with me.
Thank you. Thank you.
Ideas of India is produced by the Mercatus Center at George Mason University. If you enjoy this podcast, please subscribe on Apple Podcasts, Spotify, or your favorite podcast app. Help us grow by giving us a rating and leaving a review. Follow us on Twitter at @SRajagopalan and at Ideas of India. Also check out our initiative commemorating 30 years of India's market reforms at the 1991project.com.